SJC-12374, Commonwealth v. Jose M. Torres.
Ms. Dolberg, good morning.
Good morning. May it please the court, I'm Nancy Dahlberg. I represent Jose Torres, and this is the appeal of his conviction for one count of stalking. He was acquitted of counts alleging incidents that, according to the prosecutor, comprised a pattern of conduct constituting the stalking. The complainant in this case, without whose testimony the Commonwealth could not have obtained a conviction, submitted an application with the assistance of the District Attorney's Office for funds from the Attorney General's Division of Victim Compensation and Assistance. And she alleged in that application that she had suffered an injury caused by the defendant to her dental work. And this was one of the incidents for which Mr. Torres was indicted and acquitted. The judge described the records held by the division. So there's a division of victim assistance compensation, and there was an application which the district attorney's office assisted the complainant in filling out. So there are records maintained by the division associated with this application.
So the application was, albeit late in your view, but the application was turned over.
Yes.
Do we know what the other records consisted of?
No, we don't, because they were not summons.
Okay, that's what.
So we have never seen them. Mr. Farrader hasn't seen them. So the judge, this all happened at a last minute, in a last minute way, because the information had not been made available to anyone, I suppose the district attorney or to the defense, that such an application had been filed. So the judge indicated that she considered the records maintained by the division to be inextricably intertwined with the application itself, which the defense right away indicated from its point of view went to the bias of the complainant and financial inducement. And the judge indicated that the defense was entitled to these records to corroborate this theory. But the Attorney General's office asserted in a regulation that it wasn't allowed to provide these records, and the judge changed her position and ruled that she would not order the records to be provided, a ruling which deprived Mr. Torres of his due process rights. And I will
So counsel, in your theory here, would the better approach have been to follow the Lampron procedure in Rule 17, or is your better approach to say that anything that the AG's office has is automatic discovery because it's or not
So
automatic
we would say that
necessarily?
these are really subject to Rule 14.
Rule 14.
But there is an alternative argument here that if the court does not accept that argument,
You
that there
prefer
would be,
Rule 14?
yes, and I can certainly get into why. I briefly wanted to indicate why we maintain that the judge's ruling was incorrect. This is merely a regulation. It is not a statute. There is no statute providing that these records are privileged. It's a regulation that simply says that information, I'm paraphrasing, the information maintained by the division is confidential except as otherwise provided by law. And the judge understood the otherwise provided by law to require that there be another statute that would authorize the disclosure of these records, and that if she had been allowed to do so per an order of the court, that would have been included in the regulation. So we maintain that was an error, and that to the extent that the Attorney General's office asserts that position, it is also an error. So as to whether this is a Rule 14 or Rule 17 issue, so I think it's, despite the Commonwealth's position, unassailable that an application for monetary assistance based on the assertion that the complainant has been injured by the defendant as a result of conduct for which he's currently on trial is evidence of an inducement. And under the rules of criminal procedure and under the pretrial conference report, in this case, the Commonwealth indicated that they had provided such evidence of such inducement, statements of witnesses, which one has to assume the division records would contain, and exculpatory evidence. And the relationship between the district attorney's office and the
So
attorney...
we should,
Yes.
your view is we should treat this exactly like a cooperation agreement? Is that, so
Well, it's certainly
all the
evidence-
CHAMPA protocols are going to apply and everything else here? Is that your view? I'm trying to understand what you're asking.
I
here.
appreciate that. It is evidence of a financial inducement. Is it a written agreement between the complainant and the Commonwealth? Well, she submitted an application. She was clearly told that her cooperation was required in order to obtain the funds. She had to prove, and it was her burden to prove, that she sustained an injury as a result of a crime committed against her, and that if she made any false statements, she could be prosecuted for them. So there's an agreement of some kind, whether it's a CHAMPA agreement, that may be, that may be a step further than we see here. It's possible.
But you're asking us, you're saying the judge erred by not giving some of the CHAMPA instruction. I don't know how much you're asking for of it.
The instruction later on, in terms of, it's not a plea agreement. There's not a written plea agreement, but certainly in McGee, where the judge said, you can consider whether there are any promises, inducements, rewards, should at least have been given. Certainly.
It'd be like if there was one of those U visas, that you just sort of let the jury know. This is sort of a step ahead of where you really are, but that you should let the jury know that they can take into consideration that there was a U visa or that there was a pending application, something like that.
Yes.
But you're sort of ahead. We're sort of ahead of where you really are, because you're really at the point of, wait a minute, this is an inducement, because for her to be able to collect, there has to have been a crime. She has to tell the truth in the application, so that means she has to testify the same way in the application as at trial. And also, she gets money if there was a crime. The
Yes.
dental bills get paid.
Yes.
So therefore, it's an inducement, so whether it's Rule 14 or Rule 17, doesn't matter, it easily satisfies both.
Under one of those analyses, and I'm happy to continue on with my Rule 14, Rule 17 discussion, but absolutely, either way, even though the defense had made it clear that it was looking for information on the status of the application, and was not given that information, and the prosecutor did not tell her, the complainant was then allowed to go ahead and testify on direct that her application had been approved, that the government imprimatur, this official belief in her claim had been approved. And, that was extremely damaging to the defense and put the defense in a situation where it could not respond to that. It has no indication as to whether it was approved or not, except the complainant alleged that. She also...
Could you clarify
sorry.
something for me, please? The government has a statutory obligation to inform crime victims of compensation, correct? And that's why, at least your brother says that's the reason why it's not an inducement, or one of the reasons it's not an inducement. But here, I understand there has to be a crime, of course, for someone to be a crime victim, and that's what you argue. And that there's an explicit statutory or regulation that says the person has to cooperate in the prosecution. Does the result of the prosecution have any bearing on whether one is compensated or not?
No, I don't believe so, although, interestingly enough, that was the jury question.
Right.
The jury wanted to know, did it have to convict Mr. Torres for the complainant to receive the money for her dental work? And she did testify that she, couldn't eat or sleep as a result of damage to her mouth, which, and if I have time, I'll go on to argument 2, but, her own dentist and her own dentist records, which were then redacted by the order of the judge, indicated that it was most likely decay that caused the dental problems.
And the reason I asked you the first question about the records, because they weren't summoned, so we don't know. One argument is that your client, in effect, received all this information and used it quite effectively at trial. So how is there prejudice?
So I would really take exception to that. There's a very limited cross-examination, really, although the defense did its best. The defense was unable to respond to the assertion that the government had provided this imprimatur of its official belief in her application by the testimony that it had approved the application. She had no way to respond to that, and there was no cross-examination on that. She also was severely limited, he was also severely limited in responding to the complainant's assertion that she was no longer interested, or she was not interested in the money. She wasn't going to take the money. So why would she testify in this way? Well, the government's approved it. That's a big point with the jury. But I have no bias here because I'm not even going to take the money. And the record certainly would have contained statements that she had made about her interest in collecting the money, her need for collecting the money, and the status of the application, which the defense had specifically asked for in its Rule 17 motion, which it had to very rapidly
But just like
together.
in a cooperation agreement, you would say that the testimony that the government approved of the application is similar to the government doesn't know whether you're telling the truth or not for a cooperation agreement, right? That you can't have the imprimatur of the government saying that what you say is legitimate.
Yes, and I don't know whether the division approved the application. If the complainant got up and said, it's been approved, I'm not interested, and it hadn't approved her application,
And by government,
that's her credibility.
By government, we mean the AG's office, not the DA.
The division, yes.
All right.
So, there are her statements to the division. There's also, the division had to receive information that she received an injury caused by a crime. Her own dentist and the redactions in the dental records, which go to argument 2, indicate the dentist did not believe that, her dentist. And so what information did the division have if it approved? Did it have another dentist review records? Because not only...
But the jury, right, saw through that, right? They acquit him on the headbutting incident, don't they?
Well, they acquit him on all the underlying incidents, but
So they
I don't know. What they saw through is unclear. They certainly found the Commonwealth hadn't proven beyond reasonable doubt all the elements of those offenses. And their question certainly suggests that the basis of the conviction for stalking was impermissible because it was speculating about the legal consequences of the conviction. They wanted to know, is it going to matter if we convict him? Will she get the money, and how much money is it? That's the clearest indication I can imagine that the defendant was prejudiced.
But counsel, if they were concerned, don't you think that if they were concerned about her getting the money, they would have convicted her of something that would have resulted in the injury and not just stalking?
I don't, apparently this was not the thought process of the jury, which must have gone through all the underlying offenses and decided that they hadn't been proven. Stalking being a rather vague offense, she did testify rather vaguely that he may have threatened her on, I'll quote them, like 3 prior occasions. They could certainly have taken that if they wanted to convict him of something. And I will just go actually to my last argument very briefly, which is that the jury could well have been confused by the supplemental instruction that the judge gave in response to one of their questions, and they could have thought that there was one incident required for conviction of stalking. I just want to mention that.
If I can just go back a little bit.
Yes.
The victim witness coordinator had the application, correct?
Yes, yes,
So you don't need Rule 17 for that. That's in the custody of the DA.
yes.
In your world, in every case, the DA is going to have to reach out to the AG before he or she responds to a discovery request?
I think it would be appropriate for the Attorney General's office in each case that it receives an application for victim compensation to reach out within its own office to the extent that it is the prosecutor, or to the district attorney's office to the extent that the district attorneys are the prosecutors, and inform them that they have received an application. And then, yes, I think, and that should be made known to the defense. And in most cases, I would say it's appropriate that those records be provided.
And what if you're asking us essentially to vacate the conviction and remand? What if it turns out that there's really nothing in the file of the AG here, that there's no there?
That's always the case when records are sought and not provided. And that's, you know, if the records were here, the court could decide.
I was
But
going to
if
say,
not,
but I mean, don't we usually decide the issue of prejudice, and you're asking us essentially to find prejudice, even though we haven't had the opportunity to look to see whether or not there's any gold in them there hills of the AG's file?
But that, excuse me, Your Honor, that was true in LeBrode, too. I think it's true in any case where the records should have been provided and weren't. And there is also argument, too, here, and I see my time is up, but the redaction and limitation on the dentist's, redaction of the dentist's records and limitation on her testimony is another reason, another important basis that I would ask the court to look at.
But
Yeah.
so the jury never learned, I'm sorry, I'm not sure if I read the briefs right. Did the jury ever learn that her dentist had found that tooth decay was the cause?
So there were redactions made, and the judge instructed the defense that the dentist, who ended up being called by the defense, not by the prosecution as originally thought, that she had to testify in conformity with those redactions. So while she did indicate that she believed decay was a possible cause, her testimony was hamstrung, I would certainly argue, and the redactions would have undermined perhaps that determination. And in addition, because the application, the testimony was that the application was approved, and the jury was aware that there had to be a showing made, I think the jury would have had no choice but to think that some expert had found that the damage was caused by a crime.
And the information that it was approved came from her,
Yes.
even though the fund itself says basically, first we'll pay you above and beyond restitution, and of course there was no opportunity for restitution here because the case hadn't been tried.
This was just her testimony on direct. That's the only information we have.
All right.
Thank you very much.
Mr. Farrader, good morning.
Good morning, Your Honors. Middlesex Assistant District Attorney Timothy Farrader for the Commonwealth. I first want to make clear that victim compensation records in the possession of the AG's office will be produced pursuant to a proper Rule 17 motion. But despite the error that occurred in this case need not be remanded to the Superior Court to determine prejudice based on what was potentially in those records.
Okay, before we get there,
Sure.
the victim witness coordinator, I assume, assists in the application, and here kept a copy. Would that not be something that would be furnished as part of Rule 14 discovery?
So, yes, so the victim witness advocate did help with the application, and there was a copy of it in her files. And I admit there was delayed disclosure, but that was turned over prior to trial.
Right.
I think what the defense attorney is asking for is whatever records, additional records are in the hands of the Attorney General's
But
office.
that's, you agree with the Chief, that's Rule 14.
I disagree with that, so it's, the victim witness advocate is Rule 14.
Right, the application.
I would argue that the Attorney General's office, the Victim Witness Compensation Division, is not Rule 14 and can only be turned over pursuant to Rule 17.
Okay, but I'm sorry, but if the victim witness coordinator, or whatever the term is, advocate, has in his or her file the application, isn't that in the possession of the DA?
Absolutely, and that was turned over.
But belatedly?
Belatedly.
But you're saying it should be turned over routinely as part of Rule 14 discovery?
Correct. I think it definitely, especially in this case, I went to bias with the delayed disclosures that happened in this case by the victim. It definitely went to bias, and it was a fair point of cross-examination. And the application itself was turned over. The application, which is available on the Attorney General's website, it's just check marks and signatures signing off that you'll release all your dental records. That was turned over belatedly, but before trial, and the defense attorney was able to use that very well during cross-examination.
And do we know whether her application indeed had been approved?
I don't know, and I've never seen any of the records from the Attorney General's office, so I can't answer
Okay,
that
so,
question.
so we don't, so maybe it wasn't approved, maybe that was wrong.
Possibly. I don't know. I can't answer that question.
And maybe it was even denied because there was no evidence that the damage to her teeth came from any assault as opposed, or any crime as opposed to tooth decay.
Yes, there are, I granted a plethora of possibilities, but that leads me into my next argument. And I was asked this court, despite the error, to take the same approach that you took in Commonwealth versus Seeley, where even though the lower court didn't analyze the merits of the Rule 17 motion, this court still affirmed that conviction based on the clearly deficient Rule 17 motion. If you look at the Rule 17 motion, which is on page 40, 41, and the affidavits on 42 and 43 of the record appendix, it clearly just parrots the Lampron standard, and with one sentence that these records could possibly go to bias and curry favor with the government. As this court stated a couple months ago in Jones, Rule 17 motions require more than just mere existence. If you were just allowed a Rule 17 motion on mere existence, these statutory privileges would be essentially meaningless. Here, it's a clearly deficient Rule 17 motion, and this court can affirm the ruling based on that.
What's the privilege?
Sure, the privilege comes from the regulation, which has the force of law. The statutes give the Attorney General the power to make these regulations. 940 CMR 1409 says that all these, the application and all the documents in the possession of the Attorney General's office are confidential. I think very important in this case is that also the regulations also, or the statute also insists that an applicant grant a release to the AG's office for all their medical records or all their, if it's psychiatric records in that case, to be released. And the application itself says, I give permission to any hospital, medical facility, doctor, et cetera, for those records to be turned over to the AG's office. So now the AG's office is in possession of a large quantity of what's no doubt confidential and privileged records, especially medical records or dental records in this case. So it's very important that these records are privileged and fall under Rule 17.
How about the issue as to whether or not it was allowed or not? That's not privilege, is it?
And if the AG's records are privileged, then I think they would all be privileged.
So you're saying that the determination as to whether or not she is or is not to be awarded compensation is a privileged determination?
I haven't really thought that through, and I don't know the answer to that question in particular. But whether or not it was approved or not, one, it's not particularly, the AG's determination of liability is not admissible in this case by any regard.
But that would determine whether or not she did, well, I mean, here you sort of understand its relevance here. This may be a relatively unusual case in terms of its relevance, but you agree it is relevant here to the credibility of her claim that she was headbutted and that there was serious injury arising from the headbutt.
If the application was approved or not? I don't think
Well,
that's...
if it had been found not to be approved because they found that whatever damage to her teeth did not arise from a headbutt, would that not be something that would be relevant for a defense counsel to know?
I think it might be relevant. I think it might help them to know it, but I don't think it would be admissible evidence. Another investigation's determination of liability separate from the trial, I don't think is admissible.
If she
or relevant.
testified it was approved and it wasn't,
Correct.
that's certainly exculpatory, and if you had that information, you would have to pass it along.
Correct. It could have been undermined. It could have undermined that one particular point of testimony, but generally it wouldn't be admissible. I think they could combat that one particular point of testimony, but I think that's a pretty de minimis point in this case where I disagree with the characterization of my sister about the level of cross-examination. The level of cross-examination in terms of bias was extensive in this case. The defense attorney knew how much money she was asking for. She knew all the terms. If we want to call an agreement, they're all laid out in the statutes and regulations. She was cross-examined about all that. All of her biases in terms of this were brought out. And as the court has pointed out, the two counts, the AB serious bodily injury and the AB household family member that are related to the headbutt were both found not guilty. So I think this court can rest assured that there is no difference in this case based on that small part.
Then why is the jury asking about it, though? Don't we have to worry a little more because they are asking specific questions about it, right?
So the question, if you're referring to the question of whether or not a conviction is, an award of compensation is predicated on a conviction, I think the issue in this case was her subjective bias, and there was no testimony either way about whether an award is based on a conviction. She didn't testify that to either way. That question was never asked. I think if both parties agreed to it, the judge possibly could have given the legal instruction that it is in fact not, but both parties agreed to the instruction that you should rely on your collective memory, because I think the important part about bias is that it's the subjective biases of the victim, or the complainant and the witness, and I think all of those were clearly brought out under cross-examination. How much money she was asking for, the terms of the agreement, the need to cooperate. I mean, the cross-examination on this was extensive and apparently resonated with the jury because both of those counts were found not guilty.
Do you have any sense of what the Attorney General's file would look like?
No.
Okay,
I've never seen it.
all right.
I'm in the
No,
same
I don't mean
position.
this one specifically, but in general, how much information is in there?
No, I don't know.
Okay, because so that's sort of difficult then, because, sure, the Rule 17 motion's thin, the affidavit's a little thin, but the affidavit mentions bias, as does the, and you can understand it. This just happened the day of trial, so the defense attorney's probably scrambling to put together a Rule 17 motion, whereas if the application had been turned over 6 months earlier, you would have had a better motion and an application. So the information's clearly relevant and material because it goes to bias. It's important because there might be information in that file that goes to corroboration of injury or refutes that there's some serious dental injury resulting not from decay but from a blow. So I'm just not sure why Rule 17, if this had been 3 months earlier, wouldn't have been satisfied. All that would happen is the records would come in, there'd be a protective order, and the defense attorney would have looked at them.
So, correct, it was disclosed the Friday before trial started. Trial started on Tuesday. There hasn't been there was never a motion for post-conviction discovery and an opportunity to fill out the record as regards to why the Rule 17 motion should have been granted. So we're just left on the record of this case with a clearly deficient Rule 17 motion, and I grant you there's a plethora of possibilities of what could be in there, but as this court has repeatedly stated, both in Seeley and just a couple months ago in Jones, there has to be some specific factual information in a Rule 17 motion to not render these statutory privileges meaningless, and I think to remand this case based on the Rule 17 motion, you would have to accept that the affidavit and the motion were sufficient, which they clearly weren't in this case, and I don't think the court should set that precedent in this case.
Does Rule 17 Lampron relevance mean something different when you're talking about a regulation as opposed to a statutory privilege? Is there some fluidity there?
I don't think so. Under Dwyer and footnote 25, when it talks about when records are privileged, it says that presumptively privileged records are those prepared by persons, circumstances suggesting that the records are likely protected by a statutory privilege. Here, they're made with the regulation in mind that these are confidential, won't be turned over without the consent of the applicant, and that they also you have to sign a release providing statutory privileged material, medical records, psychiatric records, a whole plethora of information, everything the AG would be looking for the investigation has to be turned over. So I don't think that the fact that it's a regulation affects whether or not these are statutory privilege, and I don't think there's any fluidity in that. I think they're absolutely statutory privilege, especially when you're getting all these records that are always statutory privilege.
I'm going to go back to the jury's question and the answer, which is rely upon your collective memory when there was nothing in the
Correct.
in the testimony. So it was sort of somewhat bizarre to go back to your memory of evidence that doesn't exist. What do we do with Commonwealth versus Miranda, 458 Mass 100, which says, we declare, exercising our superintendent's authority, that prosecutors in the future may not provide or participate in providing monetary awards to witnesses contingent on a defendant's conviction.
Correct. That didn't
So-
happen in this case.
The answer, well,
It's the,
doesn't it mean that the victim witness payments may not be contingent upon the conviction? And should the answer to the jury have been no?
I think if the parties agree, it could have been, the judge could have given, I think, the legal instruction where it is no. Both parties agreed that they should, on the instruction, to rely on your collective memory, because I think the important part here is the subjective bias. Here, we're not in a Miranda situation. Despite them asking the questions, the Commonwealth, the district attorney's office don't certify cooperation. It's not premised on a conviction. There's an independent investigation done by the AGs who use the lower civil standard. So there isn't a Miranda situation where their reward is premised on a conviction by any
Right,
means.
but we have another situation, which is the jury may think that in order for her to get compensation to which she is entitled, they have to find him guilty of something. But in fact, the judge could have eliminated that
Correct, and we're
by
reviewing.
giving the correct legal instruction under Miranda, which is the answer has to be no. It can't be dependent upon the conviction.
And for the reason I just stated, Miranda doesn't apply here, so that instruction I don't think applies. And where both parties agreed to it, we're reviewing.
Why does it not apply?
Miranda doesn't apply because
Prosecutors may not, as a matter of law, prosecutors may not provide or participate in providing monetary awards contingent upon a conviction. Are you saying the AG could, after Miranda, say, you will get the money only if the defendant's convicted?
No, they could not do that, and that doesn't happen. So
The answer should have been, my point is, the answer, as a matter of law, to the jury should have been no.
I think that could have been a better instruction, yes. Does the.
Not a better instruction, isn't it the legally correct instruction?
It is legally correct, but the question is whether this created a substantial risk of miscarriage of justice.
Couldn't the same view be that the jury thought it was a money grab, and that's why they acquitted him of the headbutt?
Correct, so this is why I don't think there's a substantial risk of miscarriage of justice, because the speculation cuts both ways.
But let's take that and assume that you're right. Now let's look at the judge's answer to the question about proving an offense. And I as I read it, I got confused, thinking maybe there's only the necessity of one event of stalking.
Correct, so I think taken as a whole, so there's no question that the jury instruction was the legally correct diverse dates instruction. But when you take the instructions as a whole, both the supplemental and the previous instructions, the jury was instructed twice before trial on the elements of stalking that it has to be a series of at least 3 events. So they're instructed that twice, and I think it's complete speculation about whether that there's some confusion based on repeating the diverse dates instruction. So both before trial, on page 129, volume 1 and volume 4, at page 23, they were instructed twice the correct instruction on stalking that it required a series of 3 events. So taken as a whole, with the supplemental instruction and all of the instructions taken as a whole, I don't believe there is confusion or any substantial risk of a miscarriage of justice.
What is the instruction that should be given now, in your view, on these? I mean, how much of the Ciampa instruction applies in this context?
I don't think it really applies in this case where there's no vouching for the credibility of the witness. There's no agreement based on truthful testimony. There was no reward based on conviction. So I don't think it's particularly applicable in this case.
But, I mean, it has elements of it, each one. So we don't need even this careful instruction language that we're giving when we don't need that, even that in this?
No, I think these victim compensation fund the fund of last resort to fill in, as this court's recognized, restitution isn't often available.
He doesn't know that. So what Ms. Dahlberg argues is that by saying that it was approved, it's the imprimatur of a government agency saying, we bless this, we think she's telling the truth, that's why we approved it, right?
Correct. But in this case, where it's a fill-in for a civil judgment, it's a fill-in for restitution, if you're telling this...
Again, the jury doesn't know that, though. You know that.
Correct, but
All I hear it is the Attorney General said you deserve this money.
correct. The point I'm trying to make is if you give a particular care instruction to these victims, you're essentially punishing these victims for being victimized by a person who can't pay restitution or can't collect through a civil judgment, that these people, their testimony needs particular care and thought because they're getting a victim
But
compensation
perhaps the
fund
answer
reward.
is that the whether or not the Attorney General approved doesn't come into evidence.
Correct. I think that would be better, and I think there could be an instruction given fashioned around victim compensation funds, but I don't think there's anything in this case that requires this conviction to be overturned. And if there are no further questions, I'll rest on my brief.
Thank you. We'll take our morning break.
All right.